Hi, everyone. Thanks for joining me. My name is Jennifer Kirschenbaum. I am General Counsel to the New York Facial Plastic Surgery Society, and I'm going to provide some information tonight on the coronavirus, COVID-19. This is a legal update. Today's date is March 30th of 2020. The date is important because everything is changing so quickly now, day by day. Just a little bit of a disclaimer. The information that I am providing today is from sources mostly from the government, from the Department of Labor, from the New York State Governor's Office, from federal legislation that was recently passed, and certain medical society websites. So this is an ever-changing, evolving matter, and there may be updates and changes to certain information that's going to be presented here. And for your specific situations, you should always seek the advice of counsel for a one-on-one conversation. I'm going to quickly go over essential services specific to plastic surgery and some related other specialties. We'll talk about the legality of health screening for patients and staff. We're going to talk about sick benefits for employees, the CARES Act overview, business interruption insurance, tax pay date, and some other miscellaneous items, including termination. Is my practice essential? Under New York State Executive Order 202.6, the pause exempts medical practitioners from emergency care, and you are allowed to render emergency care only. And we're going to get into a little bit of what that means. So for many of us on the line, for the members of the New York Facial Plastic Surgery Society, I know many of our offices are closed, our practices are closed, and we might be available to discuss certain issues with our patients offline or by telemedicine. So I'm going to gear this talk mostly to you. So if we are a specialist that has emergencies coming in, whether it's ophthalmology or other specialties, radiology I know is still working, anesthesiology, pain management is still open in some capacity. So let's steer it towards those of us who mostly have elective procedures, and that's what I'm going to talk about. So on elective procedures, this is from CMS. The guidance is that all elective surgeries, non-essential, are to be delayed during the novel coronavirus. And actually that 2019, sorry, is a mistake from their website. I did not retype that. As more healthcare providers are increasingly being asked to assist with COVID response, it is critical that we all consider conservation of PPE, beds and ventilators. And this is from CMS. From the governor's office, Andrew Cuomo is saying that he is authorized to direct all office-based surgeries and ASCs to increase the number of beds, but this is really more for general hospitals and for those of us that have OBS and possibly have some additional items to donate. The White House has asked for the American Society of Plastic Surgery members to help meet the national COVID needs, and they're asking to see if anyone wants to donate any additional PPE that they may have and they're not using, any stockpiles. So if so, here is the link that you can click, and this link takes you directly to the ASPS website, and you can put in where your location is and what material you might have available. Telemedicine is something that maybe we have not been utilizing, or if we have, possibly we haven't been billing for. There are an exemption under Medicare rules now that they are expediting temporary eligibility status and participation in Medicare if anyone wants to take advantage of that who does not now participate. And enforcement of HIPAA is going to be relaxed during this time. So any interface that you want to use, if it's FaceTime or Zoom or all of those, I'm not going to comment on their HIPAA compliance in general because I'm not aware. You know, both of those systems may actually, in fact, be HIPAA compliant. But regardless, right now, you don't necessarily have to be super sure. You can use whatever is convenient for you to see a patient, and you are entitled to bill for that. And this is how. And this is how to get the Medicare temporary privileges and expedited enrollment. Now, the expedited enrollment is going to waive a background check. They're waiving on-site visits, and they have a hotline you can call to just get yourself set up. And if you go to this website on theplasticsurgery.org, Medicare Provider Enrollment Relief, FAQ, they'll tell you all that you need to know, which location, phone number, it's by geography you need to call, and you can get temporary privileges established. Here are coding basics for telemedicine, also provided by the Academy for Plastic Surgery. And as you can see, there are 10, 15, 25, or 40-minute increments that you can bill for audio or audio video for new patients and established. And there's a waiver of other requirements related to new patient and office visits now. So Medicare is trying to relax and make sure that patients can be seen. Actually, by happenstance, I was just checking on one of the news sources. There was an article about a patient that went to the ER for certain testing, and now the patient is complaining about bills. And it's those patients that are not necessarily, that need to go to the ER or want to be seen elsewhere, that the need for telemedicine actually is coming into play. The government is interested in the market being flooded with telemedicine providers because they want to keep the influx of the ERs down if possible. If you are have a patient that for some reason you feel you want to go in or you have to go in, there's a laceration or a closure you need to do or something, are you authorized to go to the office for an emergency service? The answer is yes, you're an essential person. So you can, and you are authorized to screen patients and to screen staff and ask them if they are symptomatic with COVID. So temperature is a main gauge that everyone has accepted. I'm not going to dictate medical terms to this audience, so you can determine what you believe is going to be appropriate and utilize whatever metric you think, knowing the symptoms of the evolving disease that you choose. If you elect to close, which some of you have, please make sure that you notify your patients the same. If you have a just in-office closure, but you're accessible, just make sure that your answering service or any message you're leaving is very clear on how patients can reach you, or if they have an emergency, that they should be contacting 911. I'm going to go over sick employee benefits quickly, because I know with this group we talked about it on a prior discussion, and so we'll go through it quick. But under New York State law right now, we are mandated of an employers and more than 10 employees, so 11 through 99, to pay 5 days of paid sick leave, which is most of us on the call. Anyone with 100 or plus more has to pay 2 weeks of paid sick leave under New York law, and anyone under 10 has to just keep the job open. And this is for someone who is already tested positive or is under mandatory quarantine or isolation for precautionary, legitimate medical need. This is not for someone who has anxiety and just wants to stay home. This is for someone who is probably sick. They are entitled to 5 days of additional paid time off that is not cumulative of what they've already potentially accrued or you give over the year. Now, if you are quarantined and you're working from home, you would be on salary still or get your hourly. You would not be entitled to these benefits. You may be eligible for additional leave under New York State paid family leave or disability benefit. Not all, just one. So if you're receiving one, you're not entitled to more or all. You can only get one benefit at a time. Okay. If an employer is closed due to COVID or a quarantine order, employees may immediately apply for unemployment insurance. So stopgap, this is my word. This is not from the law. I'm saying this is a stopgap. If you close, let's say you were previously open, you had employees, and now you realize, look, with the extension of the pause and this disease cycling through, it's going to be a few more weeks than you had previously anticipated being down for, and now you decide you're going to close your office, then individuals that are currently being paid benefit will be entitled to file for unemployment insurance. So you will not have to keep payroll going because you have individuals that are out on leave. And this information is straight from Governor Cuomo's office. So quick FAQs for New York State. Can my employer require me to use existing sick leave accruals or other accruals for a COVID quarantine order? No. Employers required to provide paid sick leave must provide that leave separate from any accruals. Do I have to apply for COVID-19 quarantine leave? No, the employer automatically has to pay it for the 5 days. If you're trying to go out on New York State paid family leave or disability, yeah, you would have to apply for that. Your job is protected when you are quarantined or on isolation. The Families First Coronavirus Response Act goes into play on April 2nd, which is this week. Covered employers or anyone who has under 500 employees. If you have fewer than 50, you could potentially ask to opt out. but you would have to actually qualify for an exemption. Qualifying reasons for a leave under this statute are employees that are subject to federal, state, and local quarantine. Again, you have to be sick, or if you're caring for someone else who is sick. It also provides coverage for individuals caring for someone else who is sick, and we'll talk about that, and also individuals who are caring for a child who's home, not able to go to school. The Act provides that covered employers must provide to all employees 2 weeks of paid time off if they are unable to work because they are sick. You have to pay 2 weeks of paid time off if they are home caring for someone else at 2/3 of the employee's salary rate. And you have to pay up to 12 weeks of the rate of pay equal to the greater of 2/3 of the employee's regular pay at 2/3 of minimum wage, or up to capped $200 per day. So that's capped, $200 a day. So 2/3 of the employee's regular rate of pay, or 2/3 of minimum wage, up to $200 a day. So 200 is the max if someone is home and says that they have to stay home to care for a child who's under 18. Next. Families First Coronavirus Response Act tax credits. If any dollar that you pay out to employees that are out on leave will be paid back to you dollar for dollar through tax credits. So this is not money that you are not going to be reimbursed for, you will. You are required to post a notice, conspicuous, in your premises of the obligations that are Family First. And again, this is for employees who claim that they need to go out on leave after April 2nd. I'm going to move now to the new law that was signed by President Trump on Friday, so we can talk about the loan construct that everyone is now going to be applying for potentially. So the CARES Act aims to put money in the hands of business owners and individuals. There's a $10,000 grant that's available as an overhead replacement, and there is a forgivable loan construct that is going to be at interest less than 4%. That is equal to your monthly payroll, which we'll go through in more detail, times 2.5 times. And it's going to be capped at $10 million. It's going to be forgivable for 8 weeks from the issuance date. So whatever you spend, and there are only allowable uses for the loan proceeds, but whatever you spend that's an allowable use during the 8-week period from issuance is potentially going to be forgivable. There are restrictions on use of funds for forgiveness. There's no prepaid penalty and 6 months deferral on payment. Unemployment benefits are also going to be supplemented because of the disease. And every individual who's on claim is going to be able to collect an additional $600 per week for each week they're on claim. And the states are going to administer that money, and they'll be responsible for setting maximums on employee compensation reimbursement. The EIDL grant is separate from the 7A loan, the forgivable loan. It is a disaster loan process under Section 7B of the Small Business Act. It enables the borrower to receive a $10,000 grant, which is money, free money, no loan, no interest, to all businesses under 500 employees. The funds to be used are for paid sick leave to employees, maintaining payroll to retain employees, meeting increased costs to obtain materials, making rent or mortgage payments, and repaying obligations that cannot be met due to revenue losses. Now, the advance amount shall be reduced from the loan forgiveness amount for a loan for payroll costs. So if you get this grant, you have to understand that it's going to be offset under the forgivable loan, because you can't double dip and get this $10,000 free, no strings, and then expect to keep the same $10,000 that you would potentially have gotten under the loan forgiveness program. I raised this slide first so that way we can talk about the section of the Small Business Act that it's under, which is 7B. I want to be very careful when you apply through SBA or through one of the institutional lenders on which loan application you are filling out. You want to be very, very, very careful here, because if you take certain funds from SBA that do not qualify for forgiveness, you may be excluding yourself from receiving additional funds under Section 7A for the forgivable loan. And so we just want to be really careful. And we're still waiting on a bunch of information on this because SBA hasn't really updated their website, and institutional lenders are all meeting early this week to figure out what their programs are going to look like. And we're going to talk about what's available. As we start going through the language related to the CARES Act, I just want to explain what I've done here. I've received 100 summaries on this law, and I'm sure many of you who are listening have also received many summaries on this law from accounting firms and from lawyers and from financial advisors, and everyone else is all sending the same bullet points. The language that we're going to go through, this is the actual law. This is what Congress has settled on and the president has signed. I think it's important for my professional clients to have an opportunity to look at the actual language so they can understand and read the construct for themselves. And if you're not interested in that, then I apologize. Now's the time for you to sign off of this webinar and go look at one of the summaries that you were previously provided, or just let your advisors to handle the whole process for you, which is also another option. So the Payroll Protection Program is loans to small businesses, less than 500 employees, part-time and full-time, including nonprofit, sole proprietors, independent contractors, and certain eligible self-employed. So to be clear, because I know some people listening to this might be part of a conglomerate or an affiliate, there are affiliation laws that are still being reviewed, and there's some dispute on or looking for further clarity on whether or not your company would potentially fall into a 500 employee and below if you are controlled by or otherwise affiliated. And those analyses are really detailed. And so you don't want to just fly by the seat of your pants. And most companies that are that size obviously would not be doing that anyway. They'll be taking their time to properly classify and confirm that they could potentially have this loan forgiven if that's what they're banking on. So there's $349 billion being appropriated from the Treasury for the cost of this loan. For the commitments, meaning that the loans that are given out from February 15th to June 30th, that's the covered period for the $349 billion to be given out. So they have until June 30th to get all this money out on the street. And I don't think it's going to last that long, and we'll see as money starts rolling out, which is hopefully going to be next week. You are allowed to use the covered loan for the following things: payroll costs, costs related to continuation of group health benefits during periods of paid sick, medical or family leave, and insurance premiums, employee salaries, commissions, or other similar compensations, payment of interest on any mortgage obligation. Now, this is for any real estate that was purchased prior to February, rent, utilities, and interest on any of their debt obligations. So just to be clear on rent, prior to you paying your landlord, you may want to consider requesting time for a deferral because you're only going to be forgiven for the loan amounts that you use during an 8-week period from issuance of the loan, which we'll get to. So if you've already paid rent for April and you're given money for you receive your loan proceeds in 2 weeks, then you may potentially want to pay April and May rent with that amount. And if you've already paid your landlord back, I don't see on this list reimbursing yourself for rent already paid. I see very clearly just rent. So you may want to think about that and how you're going to spend money. Now, the term payroll cost, which is important as we come up on how much you're entitled to under this loan to have forgiven, is important because it is going to impact how much you can take. So payroll cost means the sum of payment of any compensation with respect to employees that is salary, wage, commission, or similar compensation, and payment for group health benefits, including insurance premiums. Now, I do not consider insurance premiums here to be malpractice insurance. This is a bit amorphous, but it's going to be, I think, mostly for like New York paid family leave or whatever kind of other contribution you may be putting into for the employee. So basically, your FICA plus your insurance, your health insurance. So what it does not include is the compensation of an employee in excess of an annual salary of $100,000. So when you're sitting down and this is how the language reads, and figuring out how much payroll to include, you have to take out all the amounts of anyone who makes over $100,000 when you consider how much you're going to apply for if you want to be able to get all of it forgiven. So just be very mindful of that, because what's going to happen is, and this is what I want to be really clear about, is you're not going to be checked on the way in. Nothing is stopping every business owner in the country of any size to go on to the SBA website, which is why it's been mostly down, and you haven't been able to get through to anyone or submit anything, from printing out their, I think it's a 3-page application, filling in some very basic information. All you have to do is certify that you were open as of February, and you paid payroll, you had staff, and there's 1 or 2 other things that we're going to get to that you have to certify, and then you're entitled to this money. And you're going to put down how much money you want, and the government's going to send it to you. It's not until a couple of weeks from now, when you're going to apply for forgiveness, that you are going to be asked for documentation and support and justification for how you spent the money. And the lender at that point is going to say, oh, no. You are not entitled to forgiveness of salaries that you put in there for someone making $125,000 a year. That $25,000 extra that you asked for, that is multiplied by 2.5. So I'm not going to do the math right now. It's 70 something. That extra money that you got and you spent, we're not forgiving, and you owe us back. So you have to be very, very careful on what you anticipate, because if you don't want to take more than you're going to have forgiven, then we need to do a proper assessment on the way in and understand exactly what it is you might be entitled to. Now, the maximum loan amount, any for-profit business that's 500 or less can take the average total monthly payments by the applicant for payroll costs, so average total monthly incurred during the 1-year period before the date on which the loan is made, and multiply that by 2.5. That is the amount that you are allowed to take for this loan. So, plus any outstanding amount of a loan under Section 7B that was made during the period beginning of January 31st, 2020, and ending on the date on which the covered loans are made. So, any for-profit business is eligible to receive a maximum loan of what they've already taken under 7B, or these payroll costs times 2.5 combined. And that's capped at $10 million. So if you already have an outstanding commitment from SBA, from the government, this is going to potentially impact the amount you can take, and you need to go over what your forgiveness opportunities are. An eligible recipient requirement: you have to certify to participate that you're taking the money because of the uncertainty of the current economic conditions makes the loan necessary for you to have for ongoing operations. You're going to acknowledge that the funds will be used to retain workers and maintain payroll, or make mortgage payments, lease payments, and utility payments. You are not allowed to double dip here, okay? The eligible recipient will not be authorized to receive amounts under the section for the same purpose and duplicative of amounts applied for or received under another covered loan, okay? So just be careful on what you have outstanding. So for lending considerations, it's whether or not you were in operation on February 15th of 2020, had employees, or whether you paid independent contractors. Lender considerations more. They have the authority to make the loans under this paragraph. It's going to be extended to institutional lenders, not just the government. So I know that BAML, Signature Bank, I'm sure Chase, I'm sure all the major banks are going to, Wells Fargo, they're all going to roll this product out. They're not really going to be super incentivized to administer it, because we'll get to that, because there's no recourse for the bank, right? But the government is backing the loan. So they're not taking a personal guarantee. There's going to be no collateral that they're asking for. And the administrator is not going to be collecting any fee. The administrator, though, is the Treasury. So if you go through SBA, the administrator is not collecting a fee. So the lender, we'll get to their fees in a second, but a covered loan is going to bear an interest rate of not to exceed 4%, and there's going to be a deferment of principal and interest for a period of not less than 6 months and not more than 1 year. Okay, and as you can see here, not later than 30 days after the date of enactment of this paragraph, the administrator, which is the government, shall provide guidance to lenders. So the lenders may not have information on deferment and what the loan language should even be authorized to look like until 30 days after this was passed. So that's a lot of time for us not to know what's going on. This is what the banks are going to be entitled to make. 5% of loans of not more than on amounts committed of not more than $350. They're going to make 3% for loans more than $350 and less than $2 million. And anything over $2 million, they're only going to make 1% of the loans. So when I called, my banker and I said, listen, our law firm is going to apply for this, he said, well, I'm not too jazzed about administering this because, from the fee structure, their conventional loan constructs are, of course, a lot more lucrative. This is something that we're hoping that banks are going to be willing to take new people to help them process. But one of the answers we got from one of the major lenders is that if you don't bank here, we are not processing this loan for you. So just be mindful of that, and please reach out to your financial institution as soon as possible and try to figure out if they're going to be offering a product for you. For loan forgiveness, an eligible recipient shall be eligible for forgiveness of indebtedness on a covered loan in amount equal to the sum for the following costs during the covered period, which again, remember, the covered period is the 8-week period from when you get the money. 8 weeks, you have to pay payroll costs, any payment on interest of any covered mortgage obligation, any payment on any covered rent obligation, any covered utility payment. The term covered loan means a loan guaranteed under this section, 1106A of HR 748 is the law number right now. The covered mortgage obligation has to be something that you purchased, a real estate investment or property that you own that was bought before February 15th or 2020, or the mortgage was put on it before February 15th, 2020. And the covered period, as we discussed, means the 8-week period beginning on the date of the origination of the covered loan. That's it. You have 8 weeks to spend this money. That's it. If you took a new lease this month, you cannot pay for it now with this forgivable loan. This is for leases that were in effect prior to the pandemic starting to spread. Loan forgiveness. The expected forgiveness amount, we went over this, is payroll costs, which we talked about. Utility payments, which is defined up here, means payment for a service for distribution of electricity, gas, water, transportation, telephone, or internet access, which began before February 18th. So it's more than just utility under your lease. It's all basic utility they've included. And we covered rent, and then the mortgage obligation we discussed. Treatments of amounts forgiven. It's going to be considered canceled indebtedness. All right, and then administrators shall remit to the lender an amount equal to the amount of forgiveness plus any interest accrued through the date of payment. So this is the administrator paying off the bank, your principal and your interest. Limits on amounts of forgiveness. The amount may not exceed the principal. So we can only have forgiveness on the principal amount. You may be subject to reduction on the amount of loan forgiveness if you reduce staffing. And they're going to have a formula to calculate staffing levels. It can either be February 15th of 2019 through June 30th of 2019, or it can be from January to February, and you can pick whichever one you want for it to be judged on. Now, I want to be really clear here. The average number of full-time equivalent employees shall be determined by calculating the average number, as I said before, of full-time equivalent employees for each pay period falling within a month. But, we're not there at the but yet. Where's the but? The but is that you will not be penalized for having terminated employees. And this is where that information should be going. I want to explain that to you. So if you did fire everyone or some people, or you've limited hours or you've cut people, that's okay, because the termination periods determination periods that they're looking at are not necessarily right now today they're going to look at the 8-week period that's going to start in the issuance of the loan date. So we'll get to that slide in a minute. You could potentially have a reduction in forgiveness if you are lowering people's salaries that make under $100,000. So if you have staff that are at, say, 95 and you bring them to 65 for whatever reason, you're worried about revenue and for whatever reason, and you've modified their salary, you're bringing them back for less time, even though you have the loan, you are going to be subject to a potential reduction of the forgiveness amount. That's what this language says. This is limits on amounts of forgiveness. Again, this is exemption for rehires. So this language says there's going to be no penalty for staff previously fired during COVID being brought back. So the amount of the loan forgiveness is going to be determined without regard to a reduction in the number of full-time equivalent employees of an eligible recipient or a reduction in the salary of one or more employees of eligible recipient during the period beginning on February 15th and the date that is 30 days after the enactment of this act. So we have a month for you to bring everybody back, and you will not have an impact. So if towards the end of May, and we have to be very specific with dates, you will be able to restore your staff back to 100% and not see any penalty. Okay, application for forgiveness, and this is very important. We need to prepare for this on the way in, not on the way out. So we are going to know in advance that the amount that we request has to be confirmed and double checked. And if we don't have anyone internal to do that, then we have to work with our accountant, or we can work with our lawyer and make sure that we are correct in how we're doing the numbers. You're going to have to be ready to give payroll tax filings, state income, payroll, and unemployment insurance filings over to confirm. They can ask for, they, meaning the bank that issues this, can ask for canceled checks, payment receipts, transcripts of accounts, bank records if they don't have them already, if that's not your bank and they're not authorized to access different departments, certification that everything is true, and any other information that they may determine necessary to determine the forgiveness. They have to give you a decision on whether or not they are going to forgive the loan within 60 days of the application, which is pretty good. The amount of forgivable loan is not going to be included in gross income for tax purposes. So you're not going to have a tax hit because you had the loan forgiven, which many of us know does happen. Maturity for loans not forgiven. You are going to have potentially an amount that's not forgiven, and then you're going to have a loan in place that you have to pay back at interest of less than 4%. So the remaining balance can have a maximum maturity of 10 years from the date on which the borrower applies for the loan forgiveness. So the date you apply is the date that they're going to go back to for the loan period to start, which is nice because that I'm not sure that's going to play out with the interest, but it seems like perhaps I'm not sure if they're going to count the interest from day one, which they probably will. We'll see how this plays out. I need more information on this. So that's the end of our assessment of the loan program. If you choose for whatever reason not to get the loan and you have staff that are on unemployment, this is very important. The federal government is going to be offering an additional $600 per week to benefit for individuals on state unemployment. How is this going to play out, Jennifer? That sounds crazy. My employees are already going to be receiving probably full benefit in New York where we're located. And that amount is 5-something. So if I have an employee who makes $40,000 a year, you're telling me that they can get $55,000 a year annualized income on unemployment? No, that's not what I'm saying. I'm saying that the federal stipend is going to be $600, but the state is going to be able to administer and set its own maximum. And there's no way, and this is conjecture, but I will bet you $1 that there is no way that the state is going to pay out for unemployment more than an employee's salary. So there will be maximums put in place. I'm sure there'll be some complex formula that they enact, and it's going to be capped. Business interruption insurance. I know your broker told you you're not going to be paid out on claim. Just get in line anyway. Encourage your broker to put in. I saw legislation go up on its way to Albany today in New York. That we have some of our representatives that are pushing to have a law passed that the insurance companies have to pay for this. I know that there's been lawsuits that have been filed. Thomas Keller is a big name in the food industry who's already filed for declaratory relief that the insurance companies have to pay. So get in line. This is going to be litigated for years, and just make sure that you have a claim in. Tax payday has been pushed off to July 15th. It doesn't necessarily mean that your filing dates have been pushed off. Please make sure you speak with your accountant. Landlords have generally, as what I've seen, not been very forgiving because they are not getting any relief either. So they need the tenants to pay rent. That being said, I've seen many landlords amenable to delaying rent payments and potential deferral and amortization over a period of time that's somewhat reasonable. And again, as per my prior advice, if you are going to be getting some of these loan proceeds under the SBA, the payroll protection program, you are going to be able to use that for rent. And so you may want to accrue a balance on the rent and not pay rent right now. And you may want to speak to your landlords about that. They're going to be itching in their pants to be able to get loan money in, rent money in, because not many people are going to be paying. So I would keep yourself in that boat and see what you're going to receive on the loan, if anything, to pay, and see if you can get any late payments in your lease pushed or waived, because they would be entitled to late payments by contract, most likely. All leases pretty much have that. Terminating employees. I really don't care for the word furlough. We've talked about it before. It's not a real term that's defined. To me, it means one day the employees weren't working, one day the employees will be working at the same freight, same rate. And I don't view that as what's going to happen here. I think we're going to be a faucet, and we're going to turn on slowly, and people are going to add hours and days in our industry, at least for my medical practices. I don't think it's going to be full freight day one. We're just going to open. So I prefer to let people know their status, which is that their status right now is laid off or terminated, and then they can file for benefit if they're not going to be working. If you need individuals to work for you on a part-time basis that are normally working full-time on an hourly or even salaried, you can still ask them to work during this time period that they're on unemployment, and they can notice unemployment that they are being paid on an hourly basis to render services for you, and you can pay them fair wages, and their benefit under unemployment will just be reduced. So they would be essentially going from full-time to part-time. If you are going to be getting a salaried employee to agree to a wage reduction, which many people have done, please try to get that memorialized in writing. If it's a contracted person, like a salaried or a contractual physician that's working for you, then just simply terminating that person with no notice, taking them off of payroll, may very well be a violation of an employment agreement that you have that may require 30, 60, or 90 days notice. So you would need to speak with your staff and your doctor employees and see if they would be willing to accommodate you during this time period, possibly with a wage reduction, or if they would mutually agree, which you can of course always do, mutually agree to a modification of the agreement that during this time period there's going to be no compensation, or you're going to agree to terminate the agreement. Some employees may be looking to get out of certain restrictions, and maybe they're decided this is it. They've had enough. They're moving out of Manhattan. They're going to go move out to a different part of the country, and they want out of their agreement. You never know. So some of us who are not going to be called anywhere near the front lines, we may have some time on our hands, and you'll have time for these conversations with some of your doctors. But I've gotten plenty of emails over the last couple of weeks from associates that are saying, "Oh, this is a conversation I want to have. I may not even want to stay. So I'd be willing to go on unemployment and forego my salary if they would let me out of my restrictive covenant." So for some employers, that might be a note of a wake-up call. Hopefully, for most, your physician employees are happy and understand that in times of national crisis, we all have to cooperate. That's mostly what I've been seeing. Terminated employers are going to be eligible for unemployment, and we'll go through language and where they should go look. Mandatory employee payments on termination. Any PTO or accrued PTO includes sick and vacation. Anything in your contracts that you have said you would pay out on termination, you would have to do that. So please make sure you don't shortchange any employees. We don't want any Department of Labor complaints at the end of this once we come out the other side. Health insurance, contact your broker. Most of my clients are really very sensitive about the employees having to pick up on COBRA or pay any benefit, and they're looking for ways to work out insurance. So I have seen insurance companies extend the potential, the plans for employees out a month or so, but after that they say, look, we can't maintain the basic plan. That's what I've seen. Everyone has to switch to COBRA, or in which case that's fine. As the employer, there's nothing wrong with an employee being on COBRA. You have the option to contribute on the employee's behalf if you want. That's not going to take away from their benefit under unemployment, and there's no requirement that you do it, but COBRA sometimes is expensive, and I've seen plenty of practice owners look to take responsibility for at least a portion of it, if not all of it, during this time period. No pressure. Plenty of people are not taking that responsibility, and the employees have to do it as well. You're not required to pay any severance during this time. This is a very basic, vanilla way to terminate someone. Please be advised at this time your employment is terminated. The status change is noticed. You are telling them they may be eligible for unemployment benefits. You recommend that they contact the New York State Unemployment Department for further information, and that's it. Many of my clients do write a personalized intro, a bit of a narrative and their feelings and what's happening here, because, look, we're all in it together. I like the words involuntary workforce reduction, COVID-related. So there are some wrong ways to do this, but there's not just one right way to do it. And I find that it's not a one-size-fits-all solution. So if you want to run any language by me before it goes out, I'm happy to take a look. And it's a tough conversation, but it's one that many of us have had to have this time around. So unemployment benefits, this is what the New York State website looks like. They are waiving the 7-day waiting period for unemployment, and this is the website that you can go to. This is for New Jersey. I was asked to look at New Jersey. New Jersey also has 5 days of PTO that has to be paid right now, and to anyone who's sick. And this is for the unemployment benefits for New Jersey. So just some additional resources. The AMA resource page is very good. They have a lot of information on there. I recommend checking it out. For our firm, we have a legal page that has a lot of information on it, and a lot of webinars that we put up already on what's going on. This one will be up there too. And happy to answer any questions that you may have. Again, this is my contact information. My name is Jennifer, and I was going to take some questions from our audience, and I did receive a few. They were based off of the CARES Act as we were going through, and I had some questions on whether or not the owner of an independent contractor with his own company can file, and the answer is yes, independent contractors are authorized to file. I saw a question about the grant. If I get the grant, does that mean I'm ineligible to collect under the 7A? No, but the grant would be applied towards the amount that you keep under the grant would be subtracted from the forgivable amount of the 7A loan that you may be entitled to get. Another question is, Jennifer, what do you think about, should I wait for my bank? It's really tough. I don't know what to tell you if the SBA applicants that are just filing now are going to scoop up that money first. I don't know what the criteria is. I do know that when you look at that money divvied up and you look at the size of the companies that can apply, and there's a cap of 10 million for some of the larger companies. I don't know how many very large companies at 500 less are going to qualify and be able to apply for this thing. I don't know how much is going to be available for the little guy. $359 billion sounds like an astronomical number to me. That should be enough to go around. But when you look at it and you really cut it up, I don't know if it's going to last into the time period when we might really want to have that loan in hand, which is going to be middle to end of May, when what I've seen from our experts is probably when we're closer to more of a ramp up. To get that money next week and have to bring everybody back at full freight for salary to pay down some expenses, it seems a bit premature to go to open when, on our end, we're going to be in a period of pause, and we're not even going to be authorized to open and render services to patients. So we're going to have to see how this shakes out. Hopefully there will be more clarity on timing, and possibly, you won't be penalized for waiting until an appropriate time to apply. I also would prefer to have this loan written through your lender, because then your lender is the one who's developing and processing the criteria for forgiveness. So, my inclination is to say, email your institutional lender immediately and get some more information on when they're going to roll out a product that's responsive here. And if you could please do that, that would be the best way to go. Okay, well, I think that's it for tonight. I want to thank everyone for the time. I hope this was very helpful. And if you do have any questions, you can always contact me. We are helping our clients, as we always try to do the best we can. And we're offering a bunch of different ways for people to work with us. We're trying to be as transparent as possible during this time. And if you do have a quick question, I'm happy to get back to you, of course, free of charge. Anyone who wants us to dive in a little bit deeper, I'm happy to share with you, how we're looking to care for everyone during this time period. Okay, have a nice evening, and thanks for tuning in. Bye-bye.